Hello. Missing a deadline might be detrimental to your right and even fatal to your legal claim. So, of course, first of all, it's important to remember that there are deadlines, limitation periods, prescription periods, depending on where you apply and where you go. Uh, but what happens if you're actually missing? 'Cause sometimes it's a very short period of time, like 30 days, 45 days, 60 days, half a year. Sometimes it's more or less standard, like 2 years, 3 years, 1 year in case of defamation. Uh, Sometimes, again, when it comes to a right for appeal, it's 30 days, but there is still a possibility to do something within a half a year period of time and so forth. So the first step would be necessarily to act right away when you got a knowledge of a cause of action for yourself. And the first thing to do, to consult a lawyer, of course, but well, to verify the deadlines. Let's say it appears that some deadline is missed or to be missed. What could you do if you could? Deadlines are different in nature. Usually, the particular period is provided by a statute, a court act, a law, or a legislative act. Uh, the Civil Code of Quebec as one of the biggest of those. Uh, and depending on the wording of the document, of the decision provided for a time period, it might be strict or not. Strict one is, like strictly speaking, is a period of time which cannot be altered. So it is as it is. Uh, but often, not always, but often, those time periods can be extended by a court authorization or sometimes even some administrative process. If you meet the necessary requirements, if you can prove, basically, that you're missing the deadline was not your own negligence, was not your own fault. The most usual, should I say, reason to be relieved from such a default and to obtain the extension of time limit is a so-called impossibility to act in fact, meaning that it's not that your ideas or understanding of this world that kept you from acting, but some particular physical fact. You were sick, for example, or the information was objectively like hidden and unavailable to you, even if you did your due diligence and tried to find. Some evidence did not even exist, for example, at the time, and only recently it appeared. Uh, some knowledge of the existence of the later issued last will of the deceased, for example, this information only became available to you, I don't know, like several years after, beyond the regular 3 years period, for example. Uh, Usually you need something to prove that. It's not enough only to bring up such an allegation. Uh, a good note from a doctor, for example, would help. Some police report would help. At least some affidavits or testimonies. Maybe sometimes it's just a new administrative policy published, which suddenly opened some way which was not there previously, and so forth. So you have to prove that, but if it's possible to prove that it was impossible to act in fact, in many cases, but for those with strict time periods, de rigueur, uh, in those other cases, the courts might allow some extension just to maintain the good, sane administration of justice. Another point is when you start to calculate the period allocated. Sometimes it starts from the moment when something happened. Sometimes it starts from the moment when you obtained knowledge of the fact that something has happened. And again, there is a question of due diligence. For example, if you only got this knowledge yesterday, but in fact you could, if you did your due diligence, obtain that knowledge years ago. For example, this uh, suddenly arrived last will was all this time located in some of your trunks somewhere in your attic, where it was easily available for you if you did the search. That's one thing. But if, for example, some stranger suddenly found it where you wouldn't even think of to look for it and brought it to your attention, well, that would be another story. Uh, or maybe there was a long-lasting litigation about the access to some safety deposit box, so you couldn't access that because there was certain prohibition by court, for example, and then suddenly, years after, when you accessed it, all together with others probably, you realized that there was a document in there which was not available to you then, for example. Or again, at a significantly later date, you are informed, maybe by a certain occasion, you wouldn't even have any reason to look for that, that in fact you were by blood a son or a daughter of some deceased person, in whose either last will or because he or she died without a last will, there should be some share for you as a child of that person, but you couldn't act sooner because you didn't know, like, at all. So in such a situation, when there is no question of due diligence, usually, again, not always, consult your lawyer. The starting point is the point when you obtained the information. But this question of due diligence, phrased differently in many court decisions, is usually presented by a phrase like "you should have known." And if the court where you apply for authorization would decide that maybe you didn't know, but you should have known if you did your due diligence, your due search, if you just do whatever a reasonable person, in the circumstances would do, then it might be that even though you just learned about that yesterday, legally speaking, you should have known years ago, and therefore the starting point would be then. So to sum up, uh, in order not to miss a deadline, it's a very good idea to verify the deadlines, like, first of all, the moment you know something, because like so many cases when there was a good reason to defend somebody's right and to go to court and to obtain some protection or some relief or some award, but the person who had that, for whatever reason, waited for years and years, postponing, thinking of something maybe more important, but not having verified it. So verify, and then you decide that maybe you are already beyond the deadline. That would be one thing. Maybe the deadline is coming. That would be another thing. Because often there is something to do to put that foot into that door, just to, if the deadline is coming, to protect your future rights by doing something now, which would either suspend the time period or extend it to a certain point, and then you would have more time to decide what you actually want to do. So verify the deadlines. If necessary, do something to allow yourself more time to do the verifications and to decide what to do. But if you already missed the deadline, again, verify if it was a strict time limit or not. If it was not, do you have any good reason to explain that you were duly diligent and that you didn't have, in fact, any possibility, not in absolute terms, that's why they call it in fact, but in like reasonable terms, you didn't have a possibility to act sooner, and you might obtain uh, relief, you might obtain an extension of the time period. To sum up, there are, not to sum up, but just to say something at the end here. The summary was before. In certain situations, the courts, particularly the Court of Appeal of Quebec, accepts that if the deadline was not missed by you but by your lawyer, it was your personal impossibility to act in fact. And because of that, because of a lawyer's mistake, there is still a possibility to ask the court to extend the time limit. Though it's not always working that way, it should be an honest mistake. This is it. Thank you, and have a nice day.